Saunders, Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize, monitoring hearing in CCJ Appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Saunders, our President and the Presiding Judge.
Good morning, everyone.
Madam Justice Raj Nutley.
Good morning, everyone.
And Mr. Justice Jamada.
Good morning to everyone.
May we have the appearances, please? Thank you.
May it please your honors, Nigel Hughes with Mr. Alistair Jenkins for the appellants.
Yes.
May it please your honors, Andrew Marshallek, together with Ms. Samantha Matooth and Mr. Greg Chuck for the respondent.
Okay, thank you. Counsel, I don't know if you were formally given a sort of agenda for today's hearing, but some of the things that we wanted to discuss would include the Yemeri Grove and Laguna Village boundary dispute, the Maya land tenure policy, the delimitation process, and the revised roadmap. Is there anything else that either of the parties consider would need to be addressed today?
Mr. President, the only other matters would be the intended responses from the government to letters that were sent by us to them of the 28th of April, 26th of October, and 24th of November. But they're not major issues. I think they arise out of the matters that you've identified for the agenda.
Right. So as and when we reach that subject, then you could raise that issue if it isn't addressed. All right, so let's start with the Yemeri Grove and Laguna Village boundary dispute. Maybe Mr. Marshallek, you could start and let us know what is the current position there.
Yes, Your Honor. As you're aware from the reports, there have been a number of meetings. A draft agreement to hold a ring in the interim was prepared, circulated to the parties, and we're in receipt of comments from both sides on that draft, and we're in the process of trying to, as best we can, to accommodate all of the comments from both sides in order to finalize the document. The document is with me, and I'm trying to synthesize, try to bring them together as best I can. That's where we are.
Is that also referred to, Mr. Marshallek, as the MOU?
Yes, that is the MOU.
Okay. Yeah.
And it was marked up by both sides. And I'm trying to bring them together.
Okay. And well, you said both sides, so that there is, both sides are engaged or have been engaged so far in the process of trying to agree this MOU.
Yes, yes, Your Honor.
How much time would you need before you can complete the synthesis of the views that you have received?
I was hoping to have that done by today, but didn't make it. I would say by next week I can have those drafts circulated.
Okay. So, Mr. Hughes, is there anything that you'd like to say on this issue?
No, I just wish to confirm what my learned senior has represented to you, and we're happy that there has been significant progress since our last meeting on this matter.
Okay.
President, before you move off the matter, through you, could we maybe inquire whether there are any gaps? So we've heard a report as to what has been done and what needs to be done, but are there any gaps? Are there any areas that are still outstanding that need to be brought forward, apart from consolidating what is in hand.
Could I just, with your permission, Mr. President, inquire whether that inquiry is specifically in relation to Laguna Yameri or generally as an approach
No,
to?
for now, it is with respect to the MOU, the boundary dispute
the
we're
MOU.
talking about, right? We're talking
Yeah,
about the
that's
boundary
correct.
dispute, aren't we?
Yes,
Yeah.
that's correct. I would defer with your permission to Mr. Jenkins in relation to any gaps.
I believe that, Your Honors, good morning. I believe that the gaps are in relation to the activities that the villages can do while the dispute and the boundaries are decided and mapped out by the government. It is being proposed by Laguna that the villagers be permitted to continue in their use of the disputed zone in accordance with their Maya customary land practices. And I believe there's also a proposal by Yemery Grove that they be permitted to use and occupy the disputed zone in accordance with whatever occupation or use the government has determined that that village has used the particular zone for. So perhaps the respondents can also clarify. I'm certain that they have met with Yemery Grove to gather their comments. So I defer to the respondents as well in respect of this.
Yeah.
Yes.
Yeah. You go ahead, Mr. Marshallek.
Yes, I can respond. There is contemplated that some use will be permissible by both sides in the disputed area. What we sought to, or what was sought to be prohibited was the permanent erection of developments in the space, in the interim, things that can't be moved. And I think the dispute centered on a particular building that is under construction, that the construction seems to be continuing. And save for that particular issue, a lot of it has to do with the way the ideas are being presented and how they're being perceived. There is a heightened sensitivity even to the way things are put by the parties. And so a lot of it is language and trying to be sensitive to their concerns when formulating the positions. But in the main, I think there's agreement that certain activities can continue, that what really needs to stop for now are the activities that are that result in some permanent presence within the space.
So, Mr. Marshall, President, may I, or you?
Sure. No, go ahead.
Thank you. So, Mr. Marshall, from what I heard, you have taken all these comments on board and you're preparing a revised draft, which will be circulated again to the parties. Is that it?
Yes, that is it. That is it.
And the parties being Yemery Grove and the appellants in this matter.
I'm trying to be sensitive to the way things have been expressed is the best way I can say it.
Okay. Now
Yes,
they are defined, I don't want to say leaders, but the word in vogue now is focal points. They're defined personnel who are dealing with you on behalf of respectively Yemery Grove and Laguna Village. That is not an issue. Is that correct?
Yes, that's not an issue. The elected leaders, established leaders from both sides.
Excellent. That's really good. Okay. Now, are any of those representatives present today? Or let me ask it a different way. If I were to ask how long these villagers would need after they receive the first, you send in your responses right away. But by the 15th of December, we are hoping that an MOU would be signed by the parties.
15th of January.
January.
15th of
January.
January,
President?
15th of January, sorry, 15th of January. Okay, yes. All right, so much for that issue. We're moving along now to the draft land tenure policy. Let's start with you on your side, Mr. Hughes. Tell us what the position is there, as far as you are aware.
Thank you, Mr. President. Well, there were some initial meetings, but we raised significant concerns in our letter of the 28th of April, addressed to my learned friend on the other side, in which we set out concerns about the FPIC carve-out and other significant issues, adverse financial consequences, definition of customary land title, and some other matters. We haven't had the benefit of a response. We did on the 22nd of November, write again to my learned friend in relation to further feedback in relation to the land tenure policy. I know that's very recent, but we haven't got a response in relation to that. There are some substantial, perhaps jurisprudential issues that I think need to be addressed and agreed upon.
Mr. Hughes, can I ask with respect to the FPIC, because I had thought that the FPIC had been removed from the agenda because the FPIC has been, I don't want to say settled, but the FPIC has been working. It has been in play for some time now. And that was my impression, that we had almost taken it off the agenda. And you would see that in our email to both parties on the last occasion. I do not recall the FPIC being there. I thought that Justice Anderson had made that point in a previous hearing. Perhaps Mr. Marshall could confirm, or is it just my imagination?
Yes, Your Honor, that is so, but I think the issue goes a little past that, in that the FPIC was intended as a measure to hold the ring in the interim until the legislation is passed. And what the signal has been given in the policy is that when the legislation is passed, the requirement for consultation will be adjusted to exclude certain things, given experiences during the interim. These are things having to do with national, well, there seems to be agreement that there should be carve-outs in the case of national emergencies involving national health and national security. But the issues seems to be centered on whether there should be carve-outs for critical national infrastructure and some other language in the carve-out there. But this is to apply in the legislation, because it's not anticipated that the scope of consultations going forward, once the legislation is in place, will be the same as it is now in the interim. In the interim, it is as worded in the document, and that has been working, as you pointed out, in large part, but there's been some issues and some experiences with it where the government sees that some adjustment is needed when the law is passed. And we have signaled what those are, but the scope of those adjustments are in, I don't want to say dispute, they're different, diverging views on what they should be at this present time.
So those are matters then, if I understand you, Mr. Marshall, that you all are looking at and working on.
Yes, and they're included.
On both sides, yes.
They're included within the policy. Within the policy document. And if I can address that, I can tell you where we are with the policy and the responses. As you would have seen from the compliance reports, the last 10 or so weeks, every Saturday and Sunday, there have been all-day sessions with the 41 villages grouped in various ways, practical ways, those as part of the consultations. Those consultations are now complete, and on their completion, comments and concerns were compiled in a worksheet, And we also had a one-day working session with parliamentarians, making very similar presentation and getting views and getting feedback and lively discussion on all these issues. The result of which is that there is scheduled for tomorrow a working session with the Cabinet Subcommittee to make decisions on a lot of these issues, which I now expect they're very much familiar with and are seized out and are able to make decisions. We have not been able to offer responses to some of the requests because we're simply not in a position to decide and impose those positions on both parties. And when I say we, I mean as council representing the government. So there's been a process of convincing, discussing, and now we're at a point where decisions will be taken. That draft will be readjusted and recirculated, I hope, after tomorrow. As I said, that working session with Cabinet Subcommittee is scheduled for tomorrow at this point.
Okay, so you did receive the communication from the appellants, and the revised draft is going to take into account what was raised in those letters?
Yes, and we'll also explain the government's rationale for its position in relation to the points raised in the letters. But yes, the revised draft will take that into account. In fact, we're trying to move away now from the draft and to finalize the policy because there has been extensive consultations on the draft. The concerns have really been crystallized. They all come back to what will happen to third-party rights. This is to all the titles to land that have been issued and are in existence, within spaces that are being claimed subject to Maya customer and tenure. That's really the big issue. The other issue has to do with whether or not all the Maya villages themselves want to participate and have communal land ownership. There seems to be some issues there, more particularly acute with some villages than others, and there has to be a way to deal with that. Those are the two major ones. Apart from that, we see a lot of comments on details that can be sorted out. Even some of the comments on the draft received from the MLA, I think we will have no difficulty fitting them in. It's where they have to do with the impact on existing land titles and the extent of participation in communal lands by Maya villages themselves. And the idea there is to introduce some sort of threshold requirement, some vote by the village before it goes forward. I'm not sure what the reaction that will be. Those are just ideas being bounced around at this point. Those are some of the decisions, the things that need to be confronted.
Okay, Mr. Hughes, as I understand it, the two most thorny issues are third-party concerns, and that's a big issue, clearly. Someone may have obtained a title maybe before this consent order was settled, when the prevailing approach to land tenure and land ownership followed a particular path. The person acquired title. What is to become of that title? How is that ownership treated? Have the appellants proposed anything on that issue?
Subject to what my friend has said, we have responded to that, but I just wanted to, if with your permission, just perhaps share with you a different view. I don't think there's an issue with any of the Mayan villages participating in this. The issue came between Mayan villages if they have boundary disputes, but that's a minor issue. To come back to your question, Mr. President, we have made a proposal, but we were awaiting the government's response specifically, because it's not just limited to persons who had prior title. We have issues in relation to infrastructure, mineral and petroleum resources, all of that being part of the carve out. And I believe those areas are particularly problematic.
Yeah.
Mr. Hughes,
yeah.
I'm sorry, President.
No, go ahead.
Oh, thank you. Mr. Hughes, with respect to the third-party rights and what President had asked, what was the view of your clients on that?
I will defer for more granular response, Your Honor, to Mr. Jenkins.
Yes, Your Honors, the appellants had proposed an independent mechanism by which the parties would have agreed the principles which would govern the resolution of those disputes. So it was being proposed that the disputes, whether it's between individual landholders or between villages, whether non-Maya and not Maya, be resolved in accordance with domestic law and recognized international law. We have also proposed perhaps a mediation process first before an adjudicatory process in that adjudication process, those principles would apply. So we were waiting for a response from the respondents in relation to these proposals that were made.
President, could I just ask a little detailed question? Do you all have a sense of, by way of a survey, how many such disputes there are, and what are the, when I say the land areas, not in a strict surveying sense, but in other words, is there a list that there are 100, 50, 20, whatever number it is, of such disputes classified according to individual third-party rights and then different tribal competitive rights? Has that been mapped?
If I may, Your Honor, that is supposed to be ascertained definitively as part of the demarcation process, in that when a claim is submitted in respect of any particular area, you're supposed to also identify all the third parties to be affected by it. That said, that process is not complete. It's very early on, but our indications, our preliminary indications, is that there would have been some 8,000 titles affected. As I said, that's very preliminary. That's based on information on maps on existing software that have to be verified on the ground. But when we look at the spaces within that system and do a count, that's the neighborhood of the number of titles that have been issued within.
So Mr. One of your outputs, therefore, I'm assuming would be, as a result of the delineation process, would be to map the disputed areas, let's just call it that, or the claimed or areas, and to map both where they are and the extent of the claims, X square feet or what hectares or whatever it is. That's one part of it. And then the second part of it, I understand, is a policy or a range of options for resolving those contestations. Is that accurate?
Sorry, Your Honor, I can answer if you.
Yeah, sure.
If you wish. It was directed to Mr. Jenkins.
No. Whoever can answer. I'm just asking whether that, in other words, what an output of your process would be for everybody to know there are, let's say 8,000. There are 8,000 claims, let's call them that, and that they are for specific areas which can be shown to everybody. And that's one logistical exercise. And then a second related but independent exercise is a methodology for resolving those disputes. Mr. Jenkins says according to domestic international law, that's about his proposal, but conceptually, there will be, I'm assuming, a variety of options. For example, it may be state acquisition and compensation. I don't know. I'm just speculating, but there'll be a sort of a menu, a portfolio of options. I'm
Yeah.
trying to understand what your outputs are
Yes.
intended. What are your intended outputs? I'm sorry.
Yes, indeed, the demarcation process is to produce that map, identifying all those claims and marking them out precisely. In terms of the elephant in the room, the third party rights, third party claims, third party titles, however you want to express it, there is really no difficulty in accepting that there has to be some sort of dispute resolution mechanism can involve mediation, can involve the establishment of a tribunal. That is not where I see the difficulty is at all. I mean, we'll all agree on that mechanism. The difficulty is identifying the principles by which you're going to distill who gets to keep what, whether the title stands or falls away or must be acquired or all of that. The suggestion from our side embedded within the policy is that it's to be decided by reference, largely by reference to possession and use. That if it's being in the possession and use of the villages, then it stays. If it's not, if it's gone, the third parties, then it stays with them. That notion has been stripped out and is out of the draft presented by the appellants, so that they have a fundamental difficulty with that approach. But that is the approach that was embedded within the policy and is one of the matters that need to be considered, because as we've indicated, the real difficulty here is establishing those principles and those applicable principles. And there's an attempt by the appellants to reach into international law to gather those principles and force an application of them in the domestic scenario. And those are some of the things that will have to be discussed and decisions taken on, which is why we haven't been able to offer a response, because they're not decisions that I can take for everybody.
Thank you.
Mr. Jenkins, is that a new hand or was it up before?
That is a new hand, Your Honor. I just wanted to respond to my learned senior's comment about the difficulty that the appellants have in relation to that principle that the determination as to who has rights to the land is determined by possession. We indicated in our letter that the difficulty that the appellants have in relation to that is that it sort of redefines the Mara customary land rights. It already exists. So we have a decision on the consent order which determines how and in relation to which lands these Mara customary land rights exist. So by indicating or by limiting it to possession, it sort of distorts what has already been decided and agreed to.
Yeah, well, we can't
And
resolve that issue now, because that's going to be a very thorny issue. But of course, there are a number of principles that one would have to have recourse to, bearing in mind that what immediately I could see one of the principles being there's a consent order that occurred in a particular year, 2015 was it, or does it have retroactive effect or only prospective effect? So that is a very thorny issue. We can't resolve that issue now, but all that we could hope for is that at the end of the day, there is a framework for those contestations to be addressed, and if necessary, for courts or a tribunal set up for that purpose to resolve them. But one can certainly see that a person who, before the consent order, perhaps even before the case was brought, thought that they had acquired certain property, and whether through purchase or whatever, would have to have an opportunity to be able to assert their right to keep that property if in fact they are in possession of it and have been used in it. But I make no pronouncement one way or the other on that. That's a very difficult issue which has to be resolved down the road. At this point, all we need to focus on is there is a proper framework for accommodating those kinds of contestations and for decisions to be given on them. Anything else on the land tenure policy?
President, I don't know if Mr. Marshall was going to give us a time frame in which this would be exchanged and so on, if he can, so that we could include that.
Yes, Mr. Marshallek.
I'll explain where we are. What I've done is taken the comments and tried to make some proposals, so giving some options on how to deal with it, and ask for decisions to be taken for a firm stance to be taken on some of these things. Because we take the view that if there's going to be legislation and if there's also going to be constitutional amendment to support national legislation, then it's open to us to find some new way of resolving some of these issues and putting that into law, rather than trying to reach back and apply laws to a situation that they were never envisaged to, or never clearly envisaged to govern. So that's the approach we've been taking. I'm putting that to the committee, explaining it, and we'll grapple with that tomorrow. I'll finalize the draft in the following week, given the outcome and the decisions taken, reflecting the outcome and decisions taken, and then circulate that back to the appellants for their comments. But we also want to take the step tomorrow of getting permission to engage a draftsman and to get some sort of working draft going on the basis of that policy. Because there still needs to be consultations on that draft itself. What I don't want is to get stuck in the policy itself and not moving forward if we're to meet the deadlines which the government hopes to better at this stage. We see a need to move forward even more quickly, if not with all of it, at least with the dispute resolution mechanisms to finally keep and have people know where they stand in that area so they can plan and move forward with their lives.
Do you have a date?
So I'll say I'll circulate the draft by the end of next week.
By the December. Okay.
By the December.
That's by, well, the 9th December is a Saturday. Has there been any process, any initiative taken to inform third parties who have titles to lands which are or may be affected by the consent order, and to receive information from them about the date of their acquisition? Well, any information that might be, or is that premature? I'm just concerned that there are these third parties. We know that there are third parties. You said that 8,000, that's a substantial number of, I can't remember what you said, of titles or of persons, but there's a substantial number of persons who are or are likely to be affected. Has this process that is going on between the parties to this matter included any reaching out to those persons so that they can make any proposal that they wish to make, or is that premature?
We have not reached out to them because the list of who they are hasn't been settled. But I can tell you that the consultations that have been going on over the last 10 weeks have brought it to many of their attention. And there has been comments on the policy submitted by one landowner group without invitation. They did submit that to us. We are in receipt of it. We are considering it as well. And it has also highlighted the need for maybe even broader consultations than the ones we've undertaken with the 41 villages and the 6 or so non-Maya villages in what we have assessed to be the affected areas. But landowners are aware, and some of them have mobilized and have expressed views on that draft policy.
Because you see, I'm thinking that we in a sense are deferring a problem that we know will arise. Can't we front up that issue a little bit by publishing in the press the draft of the policy? These are just suggestions. And inviting anyone who considers that they may be affected to, in the same way that the appellants are going to be responding to the draft, inviting persons who consider that they may be affected also to present their comments. Is that something that is feasible?
Yes, we envisage that happening, but after the policy was settled and some decisions taken as how it's to propose to deal with some of these things, because in the draft they're expressed only in very general terms. Details still need to be worked out. So we had envisaged that that would happen once the policy is settled and the policy can be circulated again for comment. But in the meantime, because I think in the revised roadmap, the policy was to go to the draftsperson by January 5th. And I need to settle a policy before I send it with instructions to that draftsperson. And that was the priority just now, to get that settled and push forward. But there will be time to consult, to further invite views on the draft legislation, because what will, moving the process forward, I expect that draft will have many iterations, and there will be ample opportunity for all those concerns to be caught as part of consultations on that draft. But given the length of time that has passed and the fact that we haven't even started drafting, I wanted to settle something with sufficient detail to get at least the framework of a draft with most of it in there, that we can start having those meaningful consultations on.
President, if you allow me, I suppose maybe because maybe I'm a little new to this process, but I'm assuming an essential part of that draft is the framework for dispute resolution, because clearly there are going to be disputes. And as the president said, having an agreed framework to resolve those disputes, maybe as much as can be achieved, or that will eventually be reflected in some legislation. And I've heard that there have been different approaches to resolving the issue. But has there been some agreement on a framework for dispute resolution? For example, the creation of whatever name you give it, land dispute tribunal. You know what I mean? I don't want to say the Maya Alliance, because I think it's a little broader than that, but whatever you call it. So there is a land dispute resolution tribunal, and it may be composed of X, Y, and Z, and there may be a right of appeal to whatever. So is there has to be a formal, I would think, there has to be a formal and judicial process, because it is unavoidable that there will be disputes, and that's okay. There's no problem with having disputes. It's having a framework that can resolve them relatively effectively and efficiently. So apart from the sort of principles that will apply, because that's what somebody's saying, okay, international law, etc. Those may be governing principles, but the framework is there. I'm trying to draw a line between principles, applicable principles, and framework, because we can agree on a framework and then have a dispute as to, well, what is the law to apply, right? Yeah. So is it that you have progressed to the point where we all agree this is an acceptable framework, but where we disagree on what will be the governing principles?
We haven't yet responded, but that is pretty much, I'm giving an indication that that's where it's going. The current draft proposes a land dispute resolution tribunal. That is the mechanism. We have no difficulty with that. And rights of appeal, I don't think you're going to get much pushback on the structure of how to deal with it. I think that's fairly easy. We can adopt any of a number of approaches that exist. Don't have to reinvent the wheel. I think that the only issues are the principles be applied in resolving the issue. And we have discussed accelerating legislating the dispute resolution mechanism as a way of keeping everything peace and quiet and ordered in the interim while the legislation goes forward in its drafts. To bring that forth to the front and do that even first, separately, even before the legislation is completed. And where that idea gets stuck, again, is with the principles, not so much with the mechanism. So
President, I see that.
I think it kind of goes hand in hand.
President, I see that Mr. Jenkins has his hand up, but I don't want us to lose track of the time frame. I see that Mr. Marshallek has said that he will be sending that revised draft to the appellants on the 8th of December. So I know that Mr. Jenkins probably wants to tell us something else, but if he could, on behalf of Mr. Hughes, tell us when we can expect a response, I think that could be happily included.
Yes, Your Honors. I would just like to respond to Justice Jamador's suggestion in relation to the framework. Certainly, the appellants would agree to that suggestion of having an independent body responsible for adjudicating such disputes. And of course, we would have to agree on the principles pursuant to which that adjudication process will take place. We would welcome a meeting with the respondents to focus on this aspect. And in relation to a response to the draft land tenure policy, I believe by the 31st of December we can respond.
Excellent. Okay. All right. So the note I have here is that the government is in the process of finalizing this policy. A final draft is to be finalized by the 8th of December, and the same is to be circulated to the appellants immediately after that. The intention is to provide it to a draftsperson by the 5th of January, if possible. The appellants will provide their comments on it by the 31st of December. The draft legislation, when the draftsperson has completed their task, will be circulated to everyone and be available for all. And when I say all, I mean those 8,000 property owners who are affected or may be affected. Everyone will have, at that point, an opportunity to comment on the draft legislation. All right. Can we proceed to the revised roadmap?
President, I see two hands up. I don't know if it's
Yes.
on the last matters, Mr. Hughes and Mr. Jenkins.
Sorry. My concern was just that whether the time frame of the 31st of December for the applicants to respond in relation to the policy, whether that was not a little tight, given the time of the year and the number of applicants that have to meet and be advised and then advise themselves. That was my only concern. I don't know if Mr. Jenkins has a different view.
Certainly, if I believe because Mr. Marshall indicated that they wanted to provide the draft by the 5th of January for the legislation. But if we can be given more time, the 8th of January, then we would be grateful for that additional time.
Okay, Mr. Marshall, I know you had great hopes of giving it to the draftsperson by the 5th of January, but at that time of the year, everyone is always, consumed with the holiday season, the New Year festivities and the like. Can you push back your deadline by a week so that the appellants could give you their comments sometime early in January?
Yes, Your Honor. The date comes from the revised roadmap that we had submitted. So we were trying to stick with it, but it seems like we'll have to revise the revised roadmap again.
Yes. So let's say the appellants, you suggested, Mr. Jenkins, the 8th of January?
That's correct, Your Honor.
Okay. And well, of course, by the middle of January, I imagine that the draftsperson will be able to receive a copy of the final document. So that is how we would timetable that issue. Now, I know that in the past, we had a practice that all the circulation and drafts and so on should be copied to the court. And it would be very useful if that practice is continued. Okay. If there isn't anything else on the policy, then we move along to the revised roadmap. Mr. Marshall?
Yes, we're in receipt of correspondence. We had proposed the revised roadmap. Those dates will have to be adjusted again. But in the main, we had received correspondence in response to it. And because the actions that are being requested are actions of the Cabinet Subcommittee that involves others, I'm putting it to the working group tomorrow for a decision to be taken, and we'll communicate that decision. That's a part of the issue, because I think they're asking for a report to be submitted from the committee. And of course, I can't bind the committee to do that. I need to get them on board with it. So I'm dealing with that tomorrow, and then we can finalize the revised roadmap.
Okay, so the stage at which this is reached is it doesn't require any further consultation or submission of a draft. It's for the respondents to finalize and to present. Is that where we are at on the roadmap? The roadmap?
Mr. President, yes, indeed, but there was a proposal. In the roadmap, there's a proposal for the establishment of a review panel. And we wanted to propose that in that panel be included one or two representatives of the applicants who are familiar with the land tenure position. We've shared
I'm
this.
not.
It's set out.
Mhm.
It's set out in our letter the 26th to my friend.
Okay, so the appellants are suggesting that the parties agree on a review panel.
It has been
Um,
proposed by the other side, and we
Yeah.
agree with that.
I
But we're
see.
just saying a representative of the appellants, appropriately qualified, be part of that review panel.
I see. Mr. Mashlek,
Yes, that is indeed one of the issues. The proposal was for a review panel comprising, and I'm reading from the revised roadmap, one person selected by the appellants and one person selected by the Government of Belize for report to the Cabinet Subcommittee on the quality of draft and whether it satisfies required goals to reasonably acceptable standards. So we agreed it should be reviewed. We had said 1-1. I think the proposal is for 2, and they want to impose certain qualifications on the members of that review panel is my recollection of the correspondence. But I'm putting those proposals to the Cabinet Subcommittee. I expect a decision will be taken on that tomorrow, and I can respond.
just a second. So the proposal that a representative of the appellants be included on the review panel is going to be discussed by the Cabinet on the 1st of December, tomorrow.
Yes, that is on the agenda for tomorrow, and we're presenting the correspondences to them for their instruction, their indications of their preferences of how to deal with it. But the overall approach is not in dispute.
What is the purpose of the review panel? What is the function of the review panel?
To provide a report on the legislation for consideration of the Cabinet Subcommittee. It's to assist them to analyze, to know what the issues are when they consider it as the next step with a view to its proposal to Parliament for consideration and passage.
So are you in a position, Mr. Mashlek, to say today that that review panel will include a representative of the appellants, or is it that you are not in that position and that is an issue to be taken to the Cabinet?
No, we propose one member from each side.
I see. Okay.
I think they want, I'm not sure how many, and some qualifications.
To be a part of the draft legislation.
Yes, yes. In terms of the review, I need to double check. I don't have the correspondence in front of me. Maybe Mr. Hughes can clarify the composition of that review panel that they're contending for. But yes, we had proposed that they have some representation on the panel.
I see.
I
So
didn't want
the appellants being represented on the review panel is not an issue. There may be an issue as to the number of persons.
correct the size of it, and I didn't want to make it too cumbersome.
I see. Okay. Mr. Jenkins, you wanted to say something on this issue? You're on mute.
Yes, Your Honor. I just wanted to also add that separate and apart from the appellant suggestion that one or two members be a part of the review panel, there is a suggestion for representatives of the appellant to be involved in the drafting of the legislation. And this would be with a view to providing the particular knowledge and expertise in relation to Maya customary land practices and their relationship with the land and their governance systems. So at a policy making level, they can provide expertise so that the legislation achieves the purpose for which it is intended.
Mr. Mashlek, you have a view on this? You have a response to this?
Yes, this is an old dispute. It was originally proposed that there be 4 drafters, 2 appointed by the appellants and 2 from the respondents, and these 4 people get together and produce a draft of legislation. Of course, our view of that was that it would be too cumbersome and too slow to meet the deadlines. That the better approach is for us to produce a draft and for that draft to be reviewed by the parties as part of the process, even before it reaches the cabinet subcommittee for consideration and approval. So that was the idea behind the review panel, that we engage a draftsperson produces a draft, the review panel then reviews it and makes suggestions and generates a report. And then that report goes back with the draft to the draftsperson and to the cabinet subcommittee. And it was, the idea behind this is to expedite it, seek to get some results in a timely way. I think just convening 4 people and trying to conceptualize all of this would be difficult.
President, if I could just say, because drafting is a very specialized skill, and the expertise to frame legislation, language it, etc., requires certain competencies. I'm not sure I understand why Mr. Jenkins wants to have a group of people drafting as opposed to having an opportunity to review and comment on a preliminary draft. And exactly what his concerns are, i.e., this language, this section, this proposed subsection does not accommodate or reflect. All of those are comments that can come in, but I'm not quite clear why his method, he thinks his method is a preferred method. I'm assuming that the draftsperson is going to get instructions. I mean, I'm assuming that there's going to be, the draftsperson is going to get some preliminary instructions as to what to try and set out.
Yes, Mr. Jenkins.
Yes, Your Honor. Your Honor, the idea was to engage experts in drafting and in indigenous rights to assist in the process of drafting from that stage. It would save time and further back and forth between the respondents and the applicant. So we recognize that the particular endeavor requires certain expertise, so the appellants would have proposed certain experts in that field to assist in the drafting.
Mr. Marshallek, I'm sure that the respondents, the government, appreciates that this legislation would be technical, would be for Belize certainly novel, although not internationally novel, and it is, you know, it's not straightforward relative to other forms of legislation that Belize Parliament would have enacted. Are those considerations going to be taken into account such that appropriate expertise is sought, or is it that the normal, the usual, with no disrespect to who are the normal, the usual draftspersons, but are the normal draftspersons going to be employed to do the drafting?
No, Your Honor, it's contemplated that we'll engage an expert to do the drafting. In fact, that is one of the things that we want to move towards and get a decision on tomorrow. It's proposed that we can't put this in the normal mill for legislation production. You just won't get the results that we're hoping for within the time we're hoping for it. It needs its own attention. And I think everybody's agreed on that. So it's a matter of finding and engaging an appropriate expert to produce that first draft. And the instructions will be primarily from the policy on which the appellants have been consulted and are being consulted. So they have had a say in the instructions. We get it in the hands of the expert to draft. a draft is produced, they review again. So I don't know that, I think trying to get a drafting panel will just be too cumbersome and too slow, that this is a quicker and better way of doing it, and the concerns will still be addressed. I think the thinking is that if they put people of certain thinking and dispositions in that process, it will produce a draft that looks a particular way. Well, that may be so, but even if the draft doesn't look the way they want it to look, it can be addressed by way of the review, which is the point I think Mr. Justice Jamana was making. So we can get to the same place. It's a matter of getting to that place expeditiously, because we do have a very ambitious timetable.
Are you open to receiving the experts? Because Mr. Jenkins says he has experts who are expert legislative draftspersons with special competencies in indigenous and tribal rights, etc. Mr. Jenkins, why are you open to receiving those people's names and their CVs, so that in your selection process, your initial selection process, you will consider, we all want to reach the same place. We all want to get the best product, and we can share our resources. And if Mr. Jenkins has 4 such international experts, he can share those names with their CVs, and you can give them fair consideration. It doesn't, it may be that one of these people will be somebody who you may select. I don't know. In any event, the right of review remains, and review and comment. But Mr. Jenkins, are you willing to share your information, these?
Yes, Your Honor. We can share that information.
And are you willing to receive that information and consider these experts?
Certainly. What we're getting a decision on tomorrow is that the expert is to be identified and engaged, and then we will need to find somebody appropriate to do it. And any help in finding that person will be appreciated.
Good.
Yeah. Mr. Marshall, can I say for my part, and I know that Justices Witt and Anderson are not here today, but I hope I can speak for them to say that I am personally very pleased to see that we have reached this stage. Because I think a few months ago, it did not look like we could. And I wish to congratulate and say thanks to all the parties, all the persons who are looking at that on this call. Thank you to not just the attorneys, but the parties as well, who have worked so hard to get to this place. And I know that I just feel that we're on the right track, and that we will make a lot of progress in the coming months, and especially in early 2024. It is so important, Ms. Marshall, that process that you have envisaged and the roadmap envisages, that will be there for wide consultation by the people of Belize. And so I want to say congratulations to all and thank you.
Okay, so the note I have is that, you're welcome, that the review panel on the draft legislation will include at least one representative of the appellants.
Representative draftsperson.
Sorry, that what?
No, I was just saying representative expert as opposed to just a representative.
Oh, a representative expert.
Well,
okay.
Draftsperson, sorry.
Yes. Well, there are 2 things. Hold on, there are 2 things. There's first of all, the review panel on the legislation after it has been drafted. And that review panel will include at least one representative of the appellants. But yes, the appellants have undertaken to make available a list or an expert who may be useful, or whose skills, talents, the respondents, the government may wish to use, whether by way of consultation or by way of having that person do the drafting policy, do the drafting of the legislation. But you will make that list available, so at least they have the opportunity to look at the person's CV, compare it with any person which they had in mind themselves, and they will then have a better pool to draw from in order to have that legislation prepared. Okay, so moving along, what else is there? There is the issue of compliance reports. That's sorted out. I think that is it. Is there anything else that we need to address today?
President, I wondered whether the parties would wish to update the court on the engagement of the drafts person.
Yes, our proposal is that we resubmit a revised roadmap, and I'll insert dates for that in the revised roadmap. We'll reschedule it. There's an attempt to reschedule it here, but I think we need to get some more realistic dates in, given where we are. So we'll resubmit it in the court. I'd say by the 8th. We'll do that together with the policy.
The revised roadmap will contain all of that, and you say we will have that by the 8th of
Yes.
December. Well, thank you.
Yes, yes. And I just wanted to bring to
Just
the
can I
attention of
just
the
can I
court-
just ask a question for clarification? In that revised roadmap, given that the cabinet hopefully tomorrow will make a decision that in principle an expert drafts person be contracted, will that roadmap have a scheduling time frame for the preparation of the first draft, review, etc., so that you will have a detailed timetable to take us, now that after tomorrow you get the approval to appoint, to move from appointment of somebody, hiring somebody. You have to have time for that. So somebody will be contracted on or before a certain date, engaged, and therefore they will produce a first draft within, etc., etc. Just asking whether your roadmap will build out a detailed timetable for the delivery of a final piece of legislation.
Yes, that's what I propose. We had a timetable already, but I'm looking at it here and I'm seeing that some of it will present difficulties given the details of that we now appreciate. And yes, that's what I propose to do and deliver by the 8th, a revised, more detailed roadmap with those details, with that information in it.
Okay.
I had wanted to inform the court that that there was also, during the period under review, a working session held with the Inter-American Commission on Human Rights regarding the case that's also pending, in respect of which there's considerable overlap. And we have agreed to share compliance reports that are filed in this court with that body, so that there isn't a duplication of effort, given that this court is seized of supervision of the process, implementation of the order. So I just wanted the court to be formally aware that that is so.
Okay. So the compliance reports that are filed with the ICHR will also be filed with this court.
The other way around, the compliance report filed with this court will be copied to the
I see.
here. Yes.
Okay.
So that we don't have to do them twice.
Right. Okay, great. All right. But I want to recap some of the notes I've made in relation to today's hearing. First one, of course, had to do with the draft MOU, which is to be distributed by the 8th of December. And by the end of December, the appellants will provide their comments on it and the MOU. This has to do with the boundary dispute between Emery Grove and Laguna Village. The draft MOU is to be distributed by 8th of December, the appellants will have until the end of December for comments, and we are hoping that an MOU can be prepared and be ready for signature by the 15th of January. On the land tenure policy, the government is in the process of finalizing this policy. The final draft is to be finalized by the same 8th of December and to be circulated to the appellants. The intention is to provide it to a draftsperson by the middle of January. The appellants will provide their comments on the policy by the 8th of January. And when the draft legislation has been completed, it will be circulated to all meaning all of Belize, including in particular the appellants and those persons who are affected or may be affected. And when I say circulated, it could be published in the press or it could be made available. I'm not saying that you have to serve it on each of those 8,000 people, but it would be made available so widely so that everyone who wishes to comment on it could feel free to comment. The revised roadmap would similarly be updated and given to the appellants by the 8th of December, and it will build out a timetable for the various steps going forward. And just to get back on the legislation, we agreed that the review panel on the draft legislation, when it is completed, will include at least one representative of the appellants. And the appellants have undertaken to provide, you'll have to do this very, very soon, to provide the government with an expert or a list of experts who have expertise in the drafting process. Somebody wanted to say something?
Yes, Your Honor, we can provide that name by the 8th of December as well.
Okay, very
Or
well.
the ex
So we just put that in here. By the 8th of December. Excellent. And finally, we agree that the compliance reports that are filed with this court will be copied to the Inter-American Court so that there's no duplication and that the Inter-American Commission rather can have sight of the progress that is being made as a result of this process. Is there anything else? If not, then it only remains for me to echo what Madam Justice Rajnath has said. This is a process which was really vital for the elaboration of the consent order. It's one thing to consent to something which has as broad as the parameters as this consent order had, but it's a next and more difficult step to actually work out some of the details. We have made good progress, as Justice Rajnath indicated. There's still a lot of thorny issues to be overcome, but what is important, as Justice Rajnath, as Justice Jamila mentioned, is that there is a framework for working them out. And as they come up for resolution, some may be consensually worked out. Some may have to go through a process of litigation. And the most important thing is that the framework is one that allows for fair results based on evidence and legal arguments. I think we made good progress, and I think all that remains is for us to fix a date when we resume. Now, a lot is going to happen between now and the middle of January. So perhaps we should look for a date maybe in February. What's the interval normally that we normally have between meetings? About 3 months or so? You're on
Yes,
mute, Mr. Jenkins. Yeah.
Yes,
Okay, so we are into end of November, beginning of December now. So maybe we could look at a date in March, perhaps early March.
And of course, President, we could work backward and the parties can file their compliance reports. We
Yes.
fixed a date for that as well, but I think the important thing was for us to get the next hearing date.
Right. I'm seeing the first week of March. Maybe the 5th of March. That's a Tuesday. Is that good for everyone?
that is convenient. Yeah.
Okay, so let's say that Tuesday, the 5th of March.
President,
And
may I say, I take it by silence, our deputy registrar is indicating that it is good for the
Ye-
registry.
Yes, Justice Rajnatli. I'm also checking to
Yeah.
see if it's not Easter. No, and so far it looks good for us.
yeah, the only possible intervening issue is the moot.
It's the
I'm not
21st
sure.
and the 22nd of March. I just checked it. Mr. Noel had sent an email out this morning.
Okay.
21st to the 22nd of March, President.
Okay, good. So
Thank
the
you.
fifth seems okay. That means that the compliance reports will be due by the 21st of February. So we would send out an order indicating the timetabling that we and the various steps which the parties have agreed today. And just to, by way of reminder to everyone, and we would expect that a compliance report would be sent as to how those steps have been implemented and any other issue where we send out an email, I'm advised, not an order. Any other issues which either the parties would like to raise in their compliance order. So that email would go out this Thursday, maybe by tomorrow or Monday, the very latest. And it would apprise you of, as I said, the various things which we have agreed today and the date when we would next meet. So thanks again to all the parties and council. And we look forward to the implementation of the various steps which we have agreed and to seeing you again on the 5th of March.
Mr. President, may I take the opportunity to wish yourself and your colleagues and my colleagues in the opposing sides and everyone the best for the upcoming season.
Thank you very much, and many happy returns to you all.
Thank you.
Thank you. Thank you.
Yeah. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Madam Justice Rajnatli. Thank you, Mr. Justice Jamara. Thank you to Council, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.